Good morning. It's 9 a.m. on October 23rd. This is the second regular docket of the OCD restricted to status conferences. Freya, are we recording?
Yes, we are.
Right, excellent. Okay, I'm going to start with the first group of cases. They are joined together. Select Water Solutions 25545, 46, 47, 48, and 49. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Select.
Good morning.
Good morning, Gabrielle Gerhold on behalf of Civitas Resources in case 25549.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon, and I believe we are in cases 25545, 46, 47, 48.
All right, thank you.
Good morning, Mr. Examiner. Dina Bennett, representing Coterra Energy Operating in case number 25545. And we did object to the case moving forward.
Yes, thank you.
Mr. Hearing Examiner Matthias Sayer from Bradford Sayer on behalf of EOG Resources and matter 25549.
Okay, thank you.
One more, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating in all of the listed cases, and we are objecting.
Thank you. Ms. Gerholtz, you objected to?
Yes, thank you, Mr. Hearing Examiner.
Just wanted to make sure that, so basically all the parties that have entered an appearance in these cases have objected to the respective cases they've entered into. Ms. Vance, that's correct, isn't it?
Correct.
All right, thank you. I received a note from Freya yesterday that the parties, and when I say parties, I guess I should go to you, Ms. Hardy, because these are your cases. Are you requesting an amendment to the pre-hearing order?
Well, Select is working with the parties on technical issues and agreements. We are willing to move particularly case 25549 to the January 13th docket. That's the case in which I think everyone here almost has submitted objections, except maybe Coterra. On the others, I think we'd prefer to keep them on December 9th, but actually, I'm sorry, they're set on November 18th. So
right.
We would be willing to continue to December 9th, but I don't know if the technical examiner is available because I know that was an issue. So if December 9th is not available, we would be willing to agree to January 13th.
All right, let's first explore the separation of 49 from the other four cases. Why is that possible? Why is 49 so different from the other four that it can be separated?
Well, they're all different saltwater disposal wells in different acreage, and that's why the parties are different in that case.
I see. Okay, all right, I understand perfectly. Freya, who is the technical examiner for these cases?
It would either be Phil or Tony. I see Tony is on. He might be able to confirm availability.
Oh, great. Tony, are you with us?
Yeah, good morning.
Oh, good morning, Tony.
Yeah,
Tony, are you available? Oh, I'm sorry. Are you available? Yeah, no. These cases were set for November 18. I know we had cleared that with you previously. Is December 9 a possibility?
No, December 9th, I'm not available.
Okay, perfect. Are you available January 12? Was it 12 or 13, Freya?
It's the 13th.
Thank you. Are you available January 13?
I believe so. Just let me check. That's a Tuesday, correct?
Freya, is that a Tuesday?
Tuesday.
It's a Tuesday.
13th. Yep. Yeah, that day is open.
It is open. All right.
Yep.
Can you pencil these cases in, Tony? I'm going to grant the final continuance, but I will let you know, Ms. Hardy, that there won't be any more continuances these cases. If the parties are not ready, then these cases will have to be dismissed, then you'll have to start over again, okay?
Understood. Thank you.
I want to make sure the parties understand this too. Ms. Vance, do you understand this?
Yes.
Ms. Bennett?
Yes, I understand. Thank you.
Ms. Hartley?
Yes.
Ms. Gerhold,
Yes, thank you.
Mr. Sayer?
Yes, Mr. Hearing Examiner, and I should
Right.
note that just as not that it's terribly relevant, that this is not Ms. Hardy's. She did not initiate the movement of these to January. I started that conversation, but to the extent there's any frustration with the movement, it should be directed at me, not Ms. Hardy.
Sure. I'm not frustrated in the least. This is just a final setting for cases that were filed in early August. By January, they're almost half a year old, and that's too long to keep them on our docket. And that's part of what goes behind this. I realize that the parties are negotiating. I realize these are technical issues. So that all was calculated into amending the pre-hearing orders. So, Ms. Hardy, since they are your cases, and I always give the applicant preference when it comes to deciding on dates and continuances, would you please file a unopposed motion to continue these 5 cases to the January 13 docket?
Yes, I will do that.
Wonderful. And Freya, is this the only case on January 13 so far?
Yes.
Great. Very good. Okay. Is there anything further, Ms. Hardy, on these cases?
No, thank you very much.
Okay. Thank you, everyone. Let's move on to Matador Production. This is 255-9596. Let's just go with those 2 for now.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Matador Production Company.
Thank you.
Good morning, Mr. Examiner, Dina Bennett on behalf of Cimarex Energy of Colorado and Coterra Energy Operating. And we did file an objection to these cases moving forward by affidavit.
Thank you.
Good morning. I'm Jackie McLean with Hardy McLean on behalf of Permian Resources Operating. We also filed objection, and we have also now filed competing applications.
Oh, thank you. Do you happen to have the competing application numbers?
I do.
Go right ahead.
25717 and 25718.
Perfect. Thank you, Ms. McLean.
You're welcome.
Good morning, Mr. Examiner. Sharon Shaheen on behalf of the estate of Kenneth G. Cohn and LFN Cohn Properties, and we are simply monitoring to protect our rights at this point.
Perfect. Thank you. Did I hear from? Yeah, sorry. I think I've heard from everyone at this point. All right. So, Ms. Vance, they're your cases. How are we proceeding?
So it's news to me that there were competing applications that were filed. But I will say what we wanted to do, or it was my understanding that the parties were in negotiations, or Matador was talking with Coterra and with Permian, but we wanted to ask for another status conference because it sounded like those negotiations were going well. But at this point, that is what we would like to ask, another status conference next month. So.
Mr.
If there weren't competing applications filed, Ms. Vance, I would say, I would set it for a final status conference next month. But at this point, in addition to a status conference next month, and that's fine, I want to set this for a contested hearing. I think the parties have been provided with dates. I'll start with you, Ms. Vance. Which of those dates do you prefer?
It would be, I would prefer or Matador would prefer the January 27th, because it does leave plenty of time for additional negotiation between the parties.
It does. And Ms. McLean?
So I'm going to throw a wrench in everything. And this case, so Matador should not be surprised because we already have had one status conference in their Dick Jones cases back in September, where we said we were going to be filing competing applications, and we had all talked about a December 9th contested hearing date with that status conference of November 20th. Just to check in and make sure the December 9th was still necessary. But Permian Resources would like to proceed forward with setting that for December 9th contested hearing and having the parties have that November 20th status conference that was discussed at the last status conference in this case.
All right, thank you, Ms. McLean. Ms. Vance, do you remember any of what Ms. McLean is stating?
I do remember that this was going to be the last status conference, so I anticipated that this would be the last. However, I would have to go back and look at the transcript to confirm, regarding Permian filing competing applications. But again, I would maintain that it's my understanding that Matador is having discussions that the parties are negotiating, and the preference would be to push these out to a later date than December.
Okay, I'm looking at the notes. Hold on a second. I'm looking at the notes that were entered by Ms. Chance after the September 25th status conference. She wrote here, Coterra is in the process of filing competing applications for the 12-4 docket. And I believe, Ms. McLean, those two cases you just said will be on the 12, well, it won't be. I mean, they were filed with enough time for the 12-4 docket?
Well, so I'm looking at the transcript. I think maybe that she was confusing Coterra with Permian. And so in the transcript, we said that we had already sent out our well proposals and we were planning on filing for the November docket, and that we were fine with having this October status conference, with the understanding that the December 9th contested hearing date is out there. And then, so I think it's here in the transcript that this was very clearly discussed.
Okay.
Mr.
Yeah, I understand that there might be a mistake here in the note here, but it does say Permian will also be filing competing applications. Once competing applications are filed, council to let division know that cases need to be consolidated. It says final status conference today, 10/23, discussions about possible 12-9 contested hearing, hold off on issuing the pre-hearing order at this time. Ms. Bennett, were you trying to say something?
Yes, I was. Thank you. So Coterra had intended and still does intend to file competing applications, but there were errors in its proposal letters that were sent out. And so Coterra is working on finalizing the proposal letters. And so it hasn't yet had a chance to send out its proposal letters. So we haven't yet had a chance to file competing applications. So I do agree with Ms. Vance that a December 9th contested hearing would be premature, both because I still need to file Coterra's competing applications. And I did say on the record, and Ms. Chance's notes are correct, that Coterra did intend to file competing applications. It's just that the proposal letters had errors in them.
Okay.
And also, I just echo what Ms. Vance said, which is that the parties are moving in the direction of reaching a resolution, which would allow, as I understand it, and I'm not trying to presage anything here, but I think if the discussions are fruitful, then that would allow Coterra to move forward uncontested. And so we really do need to wait for Coterra's applications to be filed. And so I would echo Ms. Vance's request for either vacating. I haven't seen a pre-hearing order be issued, but I know we did discuss the 12-9 date, but either vacating that pre-hearing order or setting it for a January hearing date so that the parties can continue their negotiations and Coterra can get its applications on file.
Okay. All right. When do you anticipate, did you say the proposal letters have been sent or have not been sent still?
No, they're being sent today. I was texting with the landman this morning and she's stuffing the envelopes as we speak, she said.
Okay. So then 30 days, November 23rd, then you're going to need at least another. Okay. So it's basically 2 months from now would be the soonest that we could have the hearing, basically. It sounds
yes.
Like. So then that would be the January 27 contested hearing date that we've put out there would be, it sounds like the soonest that we'd be able to hear these 3 contested cases. So Ms. McLean, while I agree with you that December 9 makes the most sense based on our last discussion in September. Now I hear that there will be competing cases, et cetera, from Coterra. Do you have anything to say about that?
Well, we're not happy. Because I thought that Coterra was planning on filing for the December 4th docket, so December 9th would work. But got to go with the flow. So let's do January 27th, I guess.
Yeah. Okay. So Ms. Vance, we can have another status conference between now and January 27, but we're going to issue a pre-hearing order with Permian's cases and your cases joined together for the purposes of a contested hearing on January 27. Ms. Bennett, when you do file your cases, would you please give Ms. Chance a heads up so that we can join them with the pre-hearing order?
Yes, I will. Thank you.
All right, sounds good. Ms. Vance, anything else?
No.
All right, so when do you want to have another status conference for these cases?
I think next month would work well, if the other parties are good with that.
Yes,
I think they're nodding, so I think that works. So Ms. Vance and of course, Ms. McLean, we would end up moving your cases. Let's see now, yours 257. Freya, which docket do 257, 17, and 18 appear on now?
I'm checking, one moment.
It should be November 13th.
Perfect. So we'll move those administratively, so you don't have to worry about it.
Okay,
Those
perfect.
to the second, so it's perfect. We'll move them to the November 20th. Is it, Freya?
Yes, it is.
We'll move those from the 13th to the 20th administratively. And then Freya, would you join them to 95 and 96, please?
Yes, I will.
All right, perfect. And then Ms. Vance, would you continue these two cases to November 20th for a final status conference, even though today was the absolute final status conference?
Yes, and thank you.
Yeah, of course, of course. Well, you can thank Ms. Bennett for her typos. Is there anything further on these cases?
Not for me.
All right, thank you. All right, we're off the record in these two cases. Let's move on to Waterloo Resources, 25602.
Good morning, Mr. Hearing Examiner. Caitlin Locke for Waterloo Resources.
Morning.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC.
Your position, Ms. Bennett?
We object to the case moving forward by affidavit.
Okay.
But I will also note that the parties are in discussions, which I imagine Ms. Luck will raise later.
Okay.
Mr.
Good morning,
Examiner.
Sorry,
Go
Dana. Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company that entered an appearance and objected, and then also Oxy USA, and we've just entered an appearance on behalf of Oxy.
And does Oxy object as well?
Not right now, just an entry of appearance.
The only Matador is that you represent is objecting. Okay, thank you.
Correct.
Mr. Examiner, Dana Hardy on behalf of the Bass Management Trust entities, and we did also object.
You did. Okay. Bass Management, you said?
Yes.
Okay, thank you.
Mr.
Examiner,
Mr. Sayer,
Mr. Examiner, Ryan McKee with Beatty and Wozniak PC, appearing on behalf of Riley Permian Operating. And at this time, we're here for monitoring and preservation of rights only.
I didn't see an entry for you. Yes, I do. I do see it. And what is your name?
Ryan McKee with Beatty and Wozniak.
McKee?
Yes, sir.
McKee. Are you based here in New Mexico or are you in another state?
I am in Denver. My colleagues are participating in the Welk rulemaking, so I am filling in this morning.
Right. Of course. All right. And you said you did object? No, you did not object. Okay.
That's correct. We're just monitoring and preservation of rights only.
Mr. Sayer?
Thank you, Mr. Hearing Examiner. Matthias Sayer from Bradford Sayer on behalf of EOG Resources, and we did note an objection to moving forward by affidavit.
Do you know if your client is negotiating at this time?
I believe that they've had a conversation, but I have nothing to report on it. Caitlin might.
Sure, I'll come back to her. Okay, is there anyone else?
Yes, good morning, Mr. Examiner. Carrie Hatley, entering an appearance on behalf of Marathon Oil Permian, and we are observing only at this point, monitoring. Thank you.
Perfect, thank you. I didn't hear, Ms. Vance, you mentioned Matador. Did you also say Oxy?
Yes,
You did, okay.
that's yes, we only entered an appearance where Oxy is not objecting at this time.
You did say that, thank you. Okay, Ms. Luck, where are we?
Thank you, Mr. Hearing Examiner. I think at this point in time, due to, as you can see, so many parties that are involved in these sections and the proposed spacing unit, that we would need a continuance to the November 20th docket for another status conference. And at that point in time, we'll have a better idea about whether or not we would need a contested hearing or if we would be able to proceed by affidavit. But at this point, obviously, we can't proceed by affidavit.
What date did you file your application?
I believe our application was filed on August 20th. However, that was not early enough for the September docket. And so we had requested the October 9th docket. And then this was pushed to October 23rd just due to the nature of the objections.
So are you sure about August 20?
I apologize. My filing date might have been August 19th. Let me double check.
Well, that's okay. I'm not trying to trick you. I'm just asking you. I'll wait.
Okay. Okay, and my apologies. The application was filed on August 19th, not August 15th.
It's close enough. Thank you. Okay, so we have August 19, and you want another status conference. Where is your client when it comes to Waterloo Resources? I'm not familiar with that. Is that a holding company or what is that?
Well, Waterloo is a new operator in New Mexico in terms of oil and gas operations. They are also a non-operating entity and own a lot of mineral interests throughout the state and I've regularly appeared for them in a non-operating capacity. And now this is their first pooling application that they're filing with the state, but they are ready, willing, and able to proceed with development of the unit. They have capital funding and things like that.
Who would be the operator?
Waterloo, and Waterloo is a registered OGRD operator.
Okay, all right. Do you know how much interest they own in this land?
It would take me a moment to pull up the working interest for the whole section. I can, or for the two sections, I can if you'd like.
Yes, please.
Okay, so I'm looking back at some of the exhibits that I put together. With our landman. Okay, so for the unit recap, it looks like this is a two-section development non-standard unit, and so Waterloo has about 80 net acres, but there are also several other interests that have committed to the unit, which include August Resources, Sheep Mountain, Charborough, Riley, Jalapeno, and Chief Capital. There are several other parties that Waterloo is continuing to work with, but of course, there's lots of parties at this point that have not committed to the unit.
I see here on your application, page 2, applicant seeks to dedicate the above referenced horizontal spacing unit to the following proposed wells, and then you have a bunch of numbers that all say pending. What's the status of those now?
Well, of course, our APDs have not been filed yet because Waterloo does not have an interest in every tract in the unit. And so at this point, we just have draft C-102s prepared with those proposed wells in the Bone Spring.
All right. Okay. I understand. All right. All right. So another status conference seems advisable. It'll be the last status conference since this application was filed mid-August. And that would be next month on November 20th. So Ms. Luck, would you please continue this case to November 20th for a final status conference? And you do have some dates that we've sent out. We're going to be sending out dates from now on. It was an excellent suggestion from one of the law firms that we start sending out possible hearing dates so parties can discuss and speak to their clients about availability. So please, I think January should be sufficient. Don't you, Ms. Luck, in case you're not able to negotiate this?
Well, I will confer with my client about their availability for the January date. And then I will also circulate those dates involved, and then we will be ready to proceed and discuss matters at the November 20th hearing.
Now, you've been provided with 2 dates in January.
Okay, and I'll confirm with my client whether or not they're available.
Sounds good. All right. Is there anything else from any other party? I don't hear anything. We're off the record in this case. Thank you. Moving on to Mewbourne Oil. Excuse me?
Oh, sorry. I was just saying thank you.
You're welcome. Moving on now to Mewbourne Oil. It looks like we have, I can't tell if Miss McLean, I can't tell if, or Miss Hardy, I can't tell if these 3 are joined together or if only 2 of them are joined. So I'm just going to call 25634 for the moment.
Thank you. Dana Hardy on behalf of Mewbourne, and this is not joined with the other cases. It's separate.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC. And we did object to the case moving forward by affidavit.
Perfect. Thank you. Miss Bennett, before I go to Miss Hardy, is it your client's intention to file a competing application?
At this time, no. In fact, based on some discussions between Avant and Mewbourne, it's my understanding that Avant is willing to remove its objection if Mewbourne is willing to confirm that Avant is not being pooled. Avant acquired its interest from its predecessor, and interest was called Adventure Exploration. And Adventure Exploration is shown as a pooled party on the exhibits that Mewbourne filed. And so Avant is willing to and wants to, frankly, withdraw its objection, but also wants to make sure that it's not being pooled and its predecessor and interest is not being pooled.
Perfect. Ms. Hardy?
Mr. Examiner, I wasn't aware of that issue. I think the parties were in discussions even up to yesterday. So I don't know where Mewbourne is on removing that entity as a pooled party. I would need to confirm with them, but certainly it would be our preference to present the case by affidavit on the December 4th docket. But I need to confirm with Mewbourne. I don't know where they are in removing that entity as a pooled party.
Ms. Hardy, are you able to send an email to your client and I can recall that case in a few minutes?
Yes, I can do that.
That's great. Let's do that. Let's go off the record in that case for now. We'll come back to it.
Thank you.
Perfect. Thank you, Ms. Bennett. Okay, I'm now calling, I think, two cases that are joined together, and this is 25638 and 25641. Entries, please.
Dana Hardy on behalf of Mewburn.
Mm-hmm.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of COG, and we filed an entry of appearance and objection in these cases.
Perfect. All right, thank you. Did you say Mongoose? I didn't hear you.
Yes, so COG and Mongoose, correct.
Are they separate entities?
I believe COG is a parent company, and then Mongoose is a piece of ConocoPhillips.
Oh, okay, very good. And so you objected, and why did you object?
So Mr. Hearing Examiner, COG Mongoose plans on filing competing applications. Ms. Hardy and I did speak about these this morning. There are some similar Red Hill cases that we also filed an entry of appearance and objection to. Those have a pre-hearing order for them, and those are set for a contested hearing date on December 9th as of right now. We stated on the record at the last status conference regarding those Red Hill cases that we planned on filing competing applications, and we were going to include a request to have them moved to the December 9th contested hearing date. We obviously, and like I said, we have not filed those yet. We plan to file all of our competing applications sometime either at the end of next week or the beginning of next month. So that we can finish all of the notice timely. That being said, and again, I've made Ms. Hardy aware of this, we would very much like to push for a contested hearing date that's a little bit further out. One, the parties are discussing in negotiations right now, but two, and this is public knowledge, it can be Googled, but Conoco is going to be going through some internal shifts that could possibly result in layoffs, which means I cannot confirm that our witnesses will be available at that time. So it's a little up in the air. And so we would like to push for a contested hearing date that is in January, preferably the January 27th date if possible. But again, you know, I had that discussion with Ms. Hardy this morning. And that's the status of Conoco, of COG and Mongoose at this time.
Okay, thank you. It looks like these cases were filed by Ms. Hardy at the beginning of September. And as you know, I give the applicant preference when it comes to scheduling things. I understand that you're filing competing cases and you have a question about your witnesses' availability. Not sure what to say about that. So, Ms. Hardy?
And Mr. Examiner, the other cases that Ms. Vance was referencing, I believe, are 25594 and 25599. These two sets of cases do involve different acreage, different lateral lengths, so they are separate units. But that being said, Mewburn would really prefer to keep all four of the cases on the December 9th docket. I know the parties are in discussions, but that's our preference at this point.
Ms. Vance, 25594 and 99, were you aware of those numbers?
Yes. Those
okay,
are the...
So I'm sorry, I'm confused then. So you said you were filing next week or later this week or something. What were you talking about?
So we have COG Mongoose has competing proposals for the two separate sets of Red Hill cases. So the Red Hill cases that we had a status conference on previously, I believe it was last month, that we filed an entry of appearance and objection to. And we stated on the record that we would be filing competing applications in those, and then requesting that they be set for that December 9th date. And then with these, we entered an appearance and objection. And again, we plan to file competing applications. So that's where we are with our filings. We haven't filed any competing applications yet, but we plan to.
So 255, 94, and 99, do they compete directly with any newborn cases?
So those are the Mewborn application numbers.
Which ones? Oh, 255, 94, and 99 are newborn cases?
Those are the other Red Hills cases. Yes.
They're not on today's docket. Okay.
Right. We do have a pre-hearing order that has been issued for all 4 cases.
Okay.
So setting them on December 9th. Confusing.
I didn't understand what case numbers those.
Yeah.
Were. I understand now. So Ms. Vance, I see. So we have a pre-hearing order based on my understanding, 256, 38, and 41, 255, 94, and 99. We have those 4 cases on a pre-hearing order, but we don't have any of your cases yet on that pre-hearing order. Is that correct?
That's correct.
All right, good, excellent. And you're planning on filing those in the next 7 days or so?
Correct. It'll probably be not next week, but the following week.
Oh, I see. So either the last week of October or the first week of November.
That's correct.
I see. Okay, great.
Can I just add one comment? I understand, and I understand that Ms. Hardy, that Mewburn would like to keep that December date. I guess my only question would be, or my request would be, is if we could do another status conference, or at least if the division, if the parties were able to discuss and maybe could agree to a contested hearing date that's a little bit further out. And again, I'm not speaking for Ms. Hardy, I'm just throwing this out there. But if the parties were to agree to a contested hearing date that was further out, I would just ask if, if the division would be open to that, if all of the parties agree, that we could push to a later date in January.
So, Ms. Hardy, do you want to have, we have a December 9 contested hearing date. I'm willing to maintain that based on your request. Do you want to have another status conference between now and December 9?
I think that's fine, Mr. Examiner.
Okay, all right, very good. So, Ms. Chance, are you joining? Because I don't see 255, 94, and 99 joined with 256, 38, and 41.
It looks like they failed to be joined on the worksheet. However, I do see that they're included on the December 9th contested hearing.
Okay, can you join them?
Yeah, I'll join them. Yes.
Excellent. In our system, excellent. And then Ms. Vance, when you file your competing applications, would you please file a motion to join them with these 4 cases?
Yes, you want me to do a separate filing?
I do. Yes.
Okay.
And include a motion to amend the pre-hearing order, basically.
Yes.
Thank you. And then those will appear, as you said, those will be filed for the December 4th. Hold on a minute.
Actually, can
Go ahead.
Mr. Hearing Examiner, so at the last status conference, and I would make the same suggestion, since we already have a pre-hearing order and agreed to date, what I would ask is, can I just go ahead and put the contested hearing date in the applications?
Of course. Yeah, why pay for another moving? Yeah, agreed. And Ms. Hardy, if it's your choice, if you want to continue these 4 cases to the November 20th status conference docket, it's your discretion to do that. If you don't see a reason to do that, then you don't need to. If the parties do come to some sort of an agreement, just advise the hearing bureau. Otherwise, we'll expect to move forward on December the 9th.
Thank you. And Mr. Examiner, just because the acreage is different for the two sets, I would hope that we'd proceed with the cases sequentially on December 9th.
Okay. I didn't realize that. Again, I don't have that in front of me. Can you just be specific about what you're saying here?
Yes. So case numbers 25638 and 25641 involve sections 10 and 34 in a different lateral length from the cases in 25594 and 25599. Those latter two applications involve sections 9, 16, and 21. So there are different interest owners, different lateral lengths, those types of things. So we would just want to present, I don't think we have a preference on which set of cases goes first, but present one set first with COGs, competing applications, and then the second set.
That makes a lot of sense. So then, Freya, please don't join them. It doesn't make sense to join them. We'll just keep these two cases together, and then if you'll join 94 and 99 together, and just see that they're on the December 9 docket. Might as well hear the 255, 94, and 99 first since they're older.
That's fine.
Okay. So Freya, would you list those two in your heading for that docket as I think those are the number one cases, aren't they?
I believe we have one other hearing that day.
Okay.
That is set to go first.
All right. So number 2 then.
Yes.
And then number 3 will be these two cases where I called today. So Ms. Vance, when you do file your motion to amend the pre-hearing order, would you do something in that motion that shows us which of your two cases, or I don't know how many cases you're filing, but which of your cases compete with 255, 94, and 95, 94 and 99, and which ones compete with 256, 38, and 41?
Yes.
All right, perfect, excellent. All right, so maybe we'll see you on November 20th. Maybe we won't. Either way, you'll keep us posted onto your process.
Thank you.
We're off the record. We're off the record in these two cases. Ms. Hardy, have you heard back from your client yet, Mewborn, in the other case?
No, I'm still working on that.
Okay.
Thank you.
No worries, no worries. I'm going to move on to a case that I don't think you're involved with. This is number 12 on our docket, Taprock Operating 25639. Entries, please.
Good morning, Mr. Examiner. Michael Jewell from Jewell Jimerson on behalf of applicant Taprock Operating LLC.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating.
Ms. Bennett, if you could give me your position when you tell me who you're representing, it would be helpful.
Yes, we did object to this case and the following case moving forward by affidavit.
And the following case, is there another case?
Yes, Mr. Examiner, it might make sense if I could say that these two be joined, as the lands are adjacent, discussions are unified, at least among or between my client and the protesting party.
Okay, hold on one second. Let me pull that up because for some reason I don't have that here in front of me. Give me 1 minute. Ms. Bennett, is your client preparing competing applications?
Yes, they are. They intend to send out counter proposals sometime next week or shortly after next week. But the part Coterra is in discussions with Taprock, and so hopefully one set of applications will end up being mooted by those discussions. But for now, Coterra is planning on sending out competing proposals.
All right, let me call the other case, 25640. So Mr. Jewell, obviously that's your case. Ms. Bennett, you've also entered in that case as well?
Yes, I have, and objected to that case moving forward by affidavit.
Okay, are there any other parties?
Yes.
Good morning, Mr. Examiner. Ben Holliday on behalf of Powderhorn Operating. We are in 25639 only. We are not objecting, just monitoring.
Perfect, thank you.
Mr. Examiner, Matthias Sayer from Bradford Sayer, I'm entering an appearance on behalf of EOG Resources in 25639 and for monitoring purposes.
Okay.
And Jackie McLean, Hardy McLean representing 3R Operating, and we are also just monitoring in 25639 only.
So Mr. Jewell, I'm sorry, is there someone else?
Yeah.
Ms. Vance?
Good morning. Yes. Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Permian. And we are just monitoring in case 25640.
Thank you. I think that's everyone. Mr. Jewell, so that means that we only have one party that's preventing you from presenting your case by affidavit. Is that correct?
Yes, sir. That's my understanding.
All right, sounds good. How do you want to proceed?
We've had proposals out since April 15th, and I do concur with at least what Ms. Bennett is saying implicitly, that our parties are in discussions. We did anticipate that proposals are going out pretty soon here, but it seems to be pretty amicable moving forward. We would like to set the case for December 9th and not have any further continuances, but I realize she may ask for something a little further on. But once we get a date set, we can hold to that date and get moving. That would be wonderful as far as Tap Rock is concerned.
So if Ms. Bennett if her client is negotiating and contemplating sending proposal letters, Ms. Bennett, when would your client send out proposal letters?
They're planning on sending them out either next week or shortly after next week. So we wouldn't be able to make December 9th, but we'd be able to make either of the 2 January contested hearing dates work.
Perfect. And I think the parties have the dates in January. I'll repeat them, the 13th and the 27th. They're your cases, Mr. Jewell. You choose between 13 and 27.
And the 13th would work well.
Okay. All right. So Ms. Bennett, it sounds like your competing proposals can easily make the January 13 deadline.
Yes.
So we'll issue a pre-hearing order for these 2 cases. Ms. Bennett, when you file, please file a motion to amend the pre-hearing order.
I will.
Mr. Jewell, last time, is Taprock are you an operator in New Mexico?
Correct. Yes, sir.
But the base of your operation is Colorado?
They're based out of New Mexico. This is their 3rd iteration, but the operating LLC is the operating arm.
I see. Okay. So you are currently operating in New Mexico and you've drilled wells here?
Correct. Yes, sir.
Okay. All right. I think the last case I had with you, it sort of evaporated, right?
For a different client. Correct.
What client was that?
That was Paloma Resources.
Paloma, yes. All right. Okay. Mr. Jewell, anything further on this case?
Not from me.
Anyone else?
Thank you, Mr. Examiner.
All right, we're off the record in those 2 cases. Let's move on now to our last 2 cases before we circle back to Mewbourne Oil. This is Sarvis Permian Land Fund, 25667 and 69. Entries, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant, Service.
Thank you.
Jackie McLean with Hardy McLean on behalf of Colgate, Earthstone, and Permian Resources. And we have objected to these cases.
Perfect. Thank you.
Mr. Examiner, Jim Bruce representing Mewbourne Oil Company. Mewbourne has objected.
Good morning, Mr. Bruce. Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Paloma Permian, and we have objected.
Oh, okay.
Mr. Examiner, Matthias Sayer from Bradford Sayer on behalf of EOG Resources, entering an appearance solely for monitoring purposes.
Thank you.
Ben Holiday, entering an appearance on behalf of Powderhorn Operating. In both cases, we are monitoring, no objection.
All right, perfect. Thank you. So let's go back to Ms. McLean. You objected. Is it your intent to file a competing application?
Not at this time, and I believe that Ms. Vance had reached out to the parties about requesting an additional status conference on that November 20th date, and we're fine with that at this point.
Okay, all right. Let's go now to Ms. Bennett.
Thank you. Yes, Paloma also would like to have an additional status conference on November 20th.
Yes, okay, that's great. Is your client anticipating?
Oh, sorry.
That's okay.
No, they're not.
No. Okay. So this is really for negotiation purposes.
I can't answer that off right now. I don't know the answer to that, but I would assume so.
All right. And I feel like I left someone out here. Hold on a second.
Jim, Mewburn objected.
Thank you. Thank you. Mr. Bruce, I don't see you. So Mr. Bruce, is Mewburn anticipating competing applications?
I do not know. I have asked, and I'm awaiting a response today on that issue. But a November 20 subsequent status conference would be fine with Mewburn.
Right. Ms. Vance, when did you file these cases?
We filed on September 12th for the October 9th docket. So they're not super old.
No, of course not. This is the first hearing. Okay,
Yes.
I have no problem with November 20 for a status conference. But at that point, I would hope, since no one's really contemplating competing applications, that either you have come to some agreement or that you're ready to set this for a contested hearing.
Understood.
All right. Anything further?
Not for me.
All right, wonderful. Okay, let's circle back to Mewburn and Miss Hardy. Miss Hardy, have you heard from your client?
Yes, I have, Mr. Examiner, and they want to work on negotiating a JOA, I believe, or Avant needs to work on negotiating a JOA with them, but they're not willing at this point to remove Avant as a pulled party. So I think that leaves us in a position where we would set the case for a contested hearing on December 9th.
Mm-hmm. Do we have anything set yet, Miss Hardy? I don't know.
In this case?
Yes.
Or no, we do not.
Nothing is set yet. Okay.
Correct.
All right. This is 25634. Miss Bennett?
Well, this is a frustrating turn of events because Avant was ready to remove its objection and allow the case to move forward by affidavit. So I have not discussed with Avant whether they'd be ready for a December 9th contested hearing. We were fully expecting to reach an agreement on the record today that would allow the case to move forward. So I understand Ms. Hardy's desire to set the case for December 9th, but I think that's premature given that I was under the impression, even as of this morning, that the parties were in agreement on a path forward. So I would ask that this case be set for another status conference on November 20th. And at that point, we could discuss contested hearing dates. I think that the parties are, I'm hopeful anyway, that the parties are quite close. And if the parties have reached an agreement by November 20th, then Mewburn could move forward on December 4th uncontested.
True, all true. So what we'll do is we'll issue a pre-hearing order setting a contested hearing for December 9, and Ms. Hardy, please continue this case to November 20th for a status conference.
I will
And
do
Mr.
that.
Examiner, if it turns out that my witnesses, if the case has to go to hearing on contested hearing and the witnesses aren't available on December 9th, is there some latitude to, if I file an affidavit explaining why they're unavailable, is there some latitude to change the hearing date?
It would depend on the reasons why they're unavailable. It would also, it's hard to predict something like that. I guess I would need to see it. So let's just see if it's opposed motion or if it's an unopposed motion. I mean, there's a lot of things that go into all this.
Right, I understand. I just wanted to make sure that there is some opportunity for me to request, and it may be denied, but that it's not, you know, 100% set in stone, like chiseled in at the moment, that I have some flexibility.
Sounds good. I can't think of anything that's chiseled in stone around here, but anyway, hopefully your negotiations will be fruitful, and we'll issue a pre-hearing order, and it'll be up to Ms. Hardy. I mean, she's going to move her case to November 20 for a status conference, and at that point, she can either move it to December 4 for a hearing by affidavit, or December 9 for the contested hearing.
Sounds good.
Thank
you.
All right. It sounds like we've concluded our business today. Thank you, everyone, and we're off the record.
Thank you.
Bye-bye.